2221-1623, State of Idaho versus Chad Guy Daybell. The court will note that the state has rested its case in chief. At this time, then, I understand the defense is requesting to have a motion heard. We do have the defendant here along with defense counsel. The state's also present with the prosecutors. The jury is not present in the courtroom at this time. This motion will be argued outside of the presence of the jurors. Mr. Pryor, if you'd like to make a motion at this time, you may.
And Judge, this is a motion for a directed verdict that is permissible under the criminal rules. I'm going to do this, Judge, in a general sense without getting into specifics, but I'm going to move for a directed verdict on the murder charges, specifically with Tylee and JJ. There is no indication that Mr. Daybell was present, took an active part in, or facilitated in any way the murder of JJ and Tylee. In regards to the conspiracy charges, there's no indication that there was any act that he took in furtherance. There's reference to significant religious discussions, but that in itself is not an action in furtherance of those charges. Lastly, Judge, in regards to the fraud, the only testimony I recall is that the insurance was upped from $10,000 to $80,000, and that there had already been a longstanding $300,000 policy from 2002. At this point, I don't think the state has met its burden regarding the fraud. And again, I don't think they've met their burden regarding the conspiracy on all of the conspiracy charges, and they have not met their burden in regards to the murder as set forth previously.
All right, thank you for the argument, Mr. Pryor. Who's going to be responding for the state?
That would be me, Your Honor.
All
And I
right,
think,
Ms. Beatty, you can proceed with a response from the state.
thank you, Your Honor. On a motion for directed verdict, Your Honor, the state is entitled to all reasonable inferences that can be drawn from the evidence. And I think the case law is pretty clear that a motion for judgment of acquittal should only be granted when there is no evidence upon which to base a verdict of guilty. And that is from State versus Vargas, 100 Idaho 658. Essentially, the trial judge must review the evidence in the light most favorable to the state, recognizing full consideration must be given to the right of the jury to determine the credibility of witnesses. The jury gets to determine the weight of the evidence, as well as enjoying the right to draw all reasonable inferences from that evidence. And that's from State versus Huggins, 103 Idaho 422. Going through the charges in this case, Your Honor, first beginning with the conspiracy to commit the first-degree murder and grand theft by deception related to Tylee Ryan. The state charged a series of overt acts, and the state has presented evidence on all of those overt acts. Number one being that the defendant endorsed and espoused beliefs designed to justify the homicide of Tylee Ryan. Specifically, statements made about her being dark. These beliefs were part of the defendant's teachings, and it would be very reasonable for the jury to draw the inference that these beliefs that the defendant was espousing were designed to dehumanize these victims and justify their homicide. As to number two, that his co-conspirator Lori Vallow changed the deposit on Tylee Ryan's JP Morgan Chase account to her BBVA account. We also heard testimony from the state's financial witnesses to that effect, evidence that his co-conspirator and then mistress, Lori Vallow, moved to Idaho with his other co-conspirator, Alex Cox, as well as JJ Vallow and Tylee Ryan. Multiple witnesses testified to this. We heard evidence that the defendant himself did Google searches for the wind direction on September 8th of 2019, the last day Tylee Ryan was seen alive, and the day prior to when the state presented evidence that Tylee Ryan would have been buried on the defendant's property. That is directly related to the defendant. Number five, Alex Cox went to co-conspirator Lori Vallow's apartment where Tylee Ryan lived in the early hours of 9/9. Certainly there was evidence presented to that effect. And of note, there was also evidence that the defendant was in communication with Alex Cox at that time, and that Alex Cox's phone was in the vicinity of the defendant's residence. As to number six, that Lori Vallow never contacted Social Security. There was also testimony presented to this effect. The jury also heard that just weeks prior to Tylee Ryan's death, that Lori and Chad was aware that she would still be getting those Social Security checks after the death of Charles Vallow, which does link the defendant to that co-conspirator's actions in never contacting Social Security. Additionally, the seventh overt act, that from September of 19 to January of 2020, Lori Vallow continued to collect those checks. And during a substantial portion of this time, Your Honor, the defendant was living with her in Hawaii and enjoying the proceeds of those checks, another reasonable inference that the jury could draw. As to the first-degree murder charge of Tylee Ryan, which is count 2, the jury heard evidence that the defendant claimed that Tylee Ryan was dark, that he was, again, exchanging text messages with Alex Cox the day after she was last seen alive, that Alex Cox was in the vicinity of his residence. The jury heard evidence that the defendant texted his wife the morning of September 9, claiming that he had shot a raccoon and burnt some limbs. And then Tylee Ryan's burnt and dismembered remains were found on the defendant's property. Her DNA found on the defendant's shovel and the defendant's pickaxe in the defendant's shed. So I think there's ample evidence on that count, Your Honor, and I think that does not merit even consideration of a judgment of acquittal. As to count 3, I won't rehash all the overt acts because there is some overlap with the count 3 conspiracy to commit first-degree murder of J.J. Vallow. The first overt act we've already discussed, which is the evidence of those espoused religious beliefs justifying the homicide of J.J. Vallow. Number 2, we've already covered that the defendant's co-conspirator and then mistress, Lori, moved to Idaho with the children and with Alex Cox. Overt act number 3, the jury heard evidence that Alex Cox, the defendant's co-conspirator, took custody of J.J. Vallow. As to overt act number 4, that co-conspirator, Lori Vallow, provided false information to law enforcement regarding JJ's whereabouts. We did hear testimony of that as well. Number 5 and 6, again, those are also ones that we've already covered related to the financial issues. Count 4, the first-degree murder of J.J. Vallow. Again, we have ample evidence that a jury could use to reasonably conclude that the defendant is guilty of the murder of J.J. Vallow. In addition to the planning and preparation evidence that the jury would have heard related to the conspiracy that we've already covered, on September 23rd, the day after J.J. was last seen alive, witnesses testified at trial that they'd been staying with Lori Vallow, and that Lori told them that they not only saw Alex Cox with JJ, but that Lori then told them on the morning of the 23rd that JJ was with Alex. And the jury heard evidence about what Alex was doing that day because he was en route to the vicinity of the defendant's residence, and he was texting with the defendant that morning. Also, the jury had heard that JJ, according to the defendant, JJ was dark. We just heard evidence of that this very morning when the defendant was describing in text messages to Lori that JJ wasn't himself and that he was possessed by some type of dark entity. And like Tylee, JJ's body was found in a grave on the defendant's property. Again, ample evidence from which a reasonable jury could conclude that the defendant is guilty of the murder of J.J. Vallow. As to count 5, the conspiracy to commit the first-degree murder of Tammy Daybell. Again, the state alleged a series of overt acts and presented evidence on every single one of them. The first one, the espousing of religious beliefs similar to the other 2 conspiracy-related charges. Evidence was submitted on that. Number 2, again, we've already discussed that defendant's then mistress and co-conspirator Lori Vallow did move to Idaho to where the defendant lived, another overt act. Count 3, exchanging text messages regarding death percentages on July 30th. The jury did hear evidence of that. Overt acts 4 and 5, that the defendant and Alex Cox exchanged burner phones, that came into evidence as well. Overt act number 6, that the defendant's co-conspirator, Lori Vallow, exchanged texts regarding Tammy Daybell being possessed by dark spirits and being in limbo. The defendant and Lori Vallow were discussing that. And again, that evidence came in this very morning, Your Honor. Overt act number 7, that on September 8, the defendant signed an application along with Tammy to increase her life insurance policy to the maximum allowable under that policy. That came in via testimony and business records. Number 8, that the defendant's co-conspirator, Alex Cox, attempted to shoot Tammy Daybell. Evidence has been presented on that, Your Honor. Certainly, it's been a source of contention in this trial and a source of cross-examination, vigorous cross-examination, but ample evidence has been presented that that is exactly what occurred. Overt act number 9, that Alex Cox did multiple internet searches related to that shooting. Number 10, that Alex Cox went to the firing range in preparation for that attempted shooting. Number 11, that Alex Cox drove to from the Sportsman's Warehouse to the Daybell residence on the 9th of October of 2019. And number 12, that Alex Cox was near the Daybell residence on the 18th of October 2019 when Tammy Daybell died. All of that, all of those overt acts, the jury heard evidence on, and it would be more than reasonable for them to conclude that the defendant engaged in a conspiracy to kill Tammy Daybell. On count 6, the actual first-degree murder of Tammy Daybell, in addition to all of the preparation evidence that the jury heard related to the conspiracy, the defendant was telling numerous people in his life that Tammy was going to die soon. The jury heard evidence of that. They heard evidence that the defendant would send text messages to his mistress and co-conspirator Lori Vallow regarding how trapped he felt, but how freedom was coming. The defendant's mistress, Lori Vallow, was shopping for wedding rings before Tammy even died. The defendant then told conflicting stories about how she died, when she died. At the defendant's funeral, Chad claimed that he had miraculously asked Tammy for all of her financial passwords just days before his death, or her death. After Tammy's death, Chad immediately moved out, cashed out Tammy's life insurance policy, and went to Hawaii to live with Lori Vallow, who he married just 2 weeks later. And of course, the jury heard evidence that Tammy Daybell's death was ultimately deemed homicide by asphyxia. Again, we have ample evidence from which a jury could conclude that the defendant is guilty of the murder of Tammy Daybell. As to the final 3 counts regarding the grand theft and the insurance fraud, there were pardon? Pardon? There was a clerical issue. Thank you, Your Honor. As the final 2 counts of insurance fraud, I won't belabor this since we've already discussed it in the conspiracy portion, but the evidence does show that the defendant and Lori began an affair in 2018. Months later, Lori's husband, Charles, was killed by Alex Cox. In the immediate aftermath of that killing, Lori and the defendant exchanged text messages where Lori expressed her disappointment that she was not actually the beneficiary of Charles Vallow's life insurance policy. Then months later, not even months later, mere weeks later, the defendant goes with Tammy to increase one of her life insurance policies to the maximum allowable. And shortly after that, Tammy is killed. The jury has business records, they have testimony, they have ample evidence from which they could conclude that the defendant has committed the crimes of insurance fraud as to both the Primerica and LifeMap insurance policies. Thank you, Your Honor.
All right, thank you for the argument. The courts reviewed the motion, which is a motion brought under Rule 29 of the Idaho Criminal Rules. And this is a motion for judgment of acquittal, which reads that we're now at the time the prosecution has closed its evidence. And if the court finds, based on the standards cited there by the state, insufficient evidence, the rule reads, must enter a judgment of acquittal of any offense for which the evidence is insufficient to sustain a conviction. I've listened throughout the trial to all of the evidence submitted. There's multiple counts in this amended indictment. As I've gone through those, I'm prepared to make a ruling on nearly all of the motion here, but there is one particular issue that has arisen in the charging document, and I'd like to address that with the state if I could. So in the initial indictment filed in this case on May 25th, 2021, and I'm looking at count 4, which is the charge of first-degree murder involving J.J. Vallow. Initially, it was alleged that, quote, on or between the 22nd and 23rd of September 2019 is when the murder was committed. The state amended the indictment on February 20th, 2024, and under the amended indictment, the count 4 now reads as follows: the defendant, Chad Guy Daybell, and Lori Noreen Vallow, on or between the 8th and 9th day of September 2019 in the county of Madison, state of Idaho, and then goes on to describe the allegations about the murder of J.J. Vallow. When I look at the evidence that's been presented here from the state, the evidence not only does not support a finding of the dates between the 8th and 9th of September, but contradicts that in that J.J. Vallow was clearly alive after the 9th of September from many witnesses, including testimony today. And so I have some concern that the charging language, which would control in this case in the amended indictment, cites a date range that does not comport with the evidence. And I'm concerned about instructing jurors with evidence that I believe was never presented here at trial. It's an issue identified as we prepared for this hearing today. I understand the state may not have been aware of that. It wasn't argued by the defense, but the court has its own duty to also review the evidence and under 29, point out anything that may be considered for a potential judgment of acquittal. And so I don't know if the state is ready or willing to address the issue on the dates contained in count 4 now, or whether the state would like some additional time to look at the issue and perhaps come back a little later this afternoon and present some additional argument or authority. But I have a concern about count 4. The testimony does not comport with that. I'll note one additional point. We have an on or about instruction that's already been given and will be given. In some of the counts in the amended indictment, there are on or about language. There's also others that have on or between language. And in my mind, a plain reading of an on or between still gives a date range, but the range is from one date to another. And I don't know that that's the same as on or about, which allows maybe a further deviance of times listed in the charging information. And again, count 4 reads on or between the 8th and 9th of September. So, Ms. Beatty, do you have any response to the court's concern as it relates to count 4?
And Your Honor, if we could come back and address that perhaps Monday morning, so we have the opportunity to review that prior to the defendant's case. I'm not sure anyone was aware of.
And Judge, I need to respond for the record.
Yes. Why don't you, I did say a lot there, and Mr. Pryor offered the state a chance to respond. Any response from the defense, Mr. Pryor?
Judge, state has had an opportunity and an ample opportunity to review their pleadings. They've made amendments of those pleadings once, and we had a hearing on those amendments in which I agreed they could make whatever amendments they wanted. And now we sit on the eve of the defense starting their cause. The state has rested. The defense has made a motion under Rule 29 for a directed verdict. I don't think this gives the state the ability to make any modifications or amendments after they've rested their case, and at which time I've made a motion for a directed verdict. That motion for the directed verdict, Judge, tolls the state from making any further adjustments to the accusations they're making against Mr. Daybell, and I'm suggesting I'd ask the court to make its ruling on my directed verdict.
All right. I'd note there's actually a rule that governs this directly, Idaho Criminal Rule 7E. The court may permit amendment of an indictment, quote, at any time before the prosecution rests. So I do agree with the defense there that amendment of the indictment's not permitted at this stage in the trial. In terms of the timing and the request by the state, the issue with waiting until Monday is if the defense is going to be prepared to start with its case in chief, the defense is entitled to know what it's defending against, and if potentially one of these counts is dismissed on a judgment of acquittal under Rule 29, that would affect potentially, in fairness, preparation for the defense. So in my mind, it's a fairly narrow issue where we have a filed amended indictment. We've got Criminal Rule 7E, we've got Criminal Rule 29, we've got our jury instruction number 4, which might be relevant on the honor about or honor between language. 221-1623 State of Idaho versus Chad Guy Daybell. We took a recess after the court heard argument on the defense motion for judgment of acquittal under Criminal Rule 29. I indicated an issue with count 4 and permitted additional time for the state. Before going into more argument on count 4, I have taken the time to prepare a ruling on the other counts on the motion. And I think for efficiency purposes would go through the ruling I've got as it relates to the other counts in the case, and then reserve some additional time to further discuss where things will stand with the count 4 of the amended indictment. So proceeding in that manner, the court would first note that the motion under Rule 29 for a judgment of acquittal, as I mentioned before, is for the court to consider whether there's evidence insufficient to sustain a conviction. There's some case law that goes further into the standard of review on that, or the burden of proof the court looks at in determining this motion. Some of it cited appropriately by the state. I'll note from a case, State versus Taylor, 157 Idaho 186, talks about, says under ICR 29, the district court may set aside a jury verdict or enter a judgment of acquittal if the evidence is insufficient to sustain a conviction. The 14th Amendment of the United States Constitution guarantees the right to due process, and the U.S. Supreme Court has held that as part of that due process, quote, no person shall be made to suffer the onus of a criminal conviction except upon sufficient proof defined as evidence necessary to convince a trier of fact beyond a reasonable doubt of the existence of every element of the offense. And there's some internal cites there. Going on, the case states the relevant inquiry is not whether this court would find the defendant to be guilty beyond a reasonable doubt, but whether, quote, after viewing the evidence in the light most favorable to the prosecution, any rational trier of fact could have found the essential elements of the crime beyond a reasonable doubt. And that cites a case, State versus Adamanchik, 152 Idaho 460. And then finally, thus, the only inquiry for this court is whether there is substantial evidence upon which a reasonable jury could have found that the state met its burden of proving the essential elements of the crimes charged beyond a reasonable doubt. Substantial evidence is more than a scintilla of proof, but less than a preponderance. In short, it is relevant evidence which a reasonable mind might accept to support a conclusion. So finally, the court is required to consider the evidence in the light most favorable to the state, but will not substitute its judgment for that of the jury on witness credibility, weight of the evidence, or reasonable inferences to be drawn from the evidence. So that's the standard of review the court considers in ruling on a motion under Criminal Rule 29, starting then with the counts that I am prepared to rule on. On count 1, having considered the arguments of the defense and the state, the court does find that the state has presented sufficient evidence that would permit a reasonable trier of fact to find the essential elements of the crime beyond a reasonable doubt. And that's on the conspiracy to commit first-degree murder and grand theft by deception involving victim Tylee Ryan. The court notes that on identification of the defendant, which is one of the elements. He was identified by several witnesses, including Detective Ray Hermosillo, Ron Arnold, Detective Kaya Kamanu, that in terms of the dates listed in count one, surveillance from Officer Joe Powell helped establish those in the testimony of the other witnesses I mentioned, that this occurred in the county of Madison, state of Idaho. There were locations testified to by Officers Joe Powell, Colin Nesbitt, that the victim, Tylee Ryan, was identified in that count by, among others, Colby Ryan. Looking at the overt acts that the state went through and alleged 1 through 7, the overt acts, evidence of those came in sufficient to withstand a Rule 29 acquittal from Detective Nathan Duncan and Zulema Pastenis testified to some of this. Also on the second overt act, Michael Douglas, Mark Sari, Chuck Considas. Also Chuck Considas on the third overt act. Detective Nathan Duncan testified on issues related in the fourth overt act. On the fifth overt act, Nicholas Balance and Nicole Heidemann testified about that. On the sixth overt act, Mark Sari, Chuck Considas testified regarding that, and Mark Sari also on the seventh element. The court then, in considering that standard on a Rule 29, finds there's sufficient evidence, and so the motion's denied and the jury will be allowed to consider count one. Count two is the first-degree murder charge of Tylee Ryan, and evidence was provided identifying the defendant by witness Ron Arnold. There was date indications of when this occurred established by Rick Wright, among other witnesses. And the plan that is referenced in there was also testified to by Rick Wright and Nick Edwards. There was also information about identifying Tylee Ryan, identifying her as a person by Colby Ryan, Tara Martinez, Dr. Garth Warren. And looking overall at the evidence submitted, the court does find the state's met its burden to withstand a Rule 29 motion, and count two, the judgment of acquittal motion, is denied. Moving next to count three, conspiracy to commit first-degree murder of J.J. Vallow. The court notes there was sufficient testimony and evidence presented to also deny the motion for judgment of acquittal on this count three. The identification of the victim established by witnesses including Kay Woodcock and Brandon Boudreau, that the overt acts again were testified to by witnesses including Zulema Pastenis, David Gibb, Ashlyn Rand, David Warwick, Melanie Gibb, Colby Ryan, Ray Woodcock, Mark Sari, all testified among those seven, actually six overt acts that are alleged there. The court does find sufficient evidence in testimony and admitted exhibits to allow the state to move forward and seek jury deliberation on that count. I'll skip over count four, as I mentioned. On count five, this is the conspiracy to commit first-degree murder of Tammy Daybell. Also, the court denies the motion for judgment of acquittal under Rule 29. In that particular count, the identification of the victim was established by Samantha Gwilliam and others. The defendant was identified relating to that count by testimony from Craig Huff, Zulema Pastenis, Colby Ryan. Looking at the overt acts established, there were 12 in that count, and the court notes that there was, again, identification of the victim, Tammy Daybell, by Samantha Gwilliam. On count one, some evidence came in through testimony of Jason Gwilliam, Ian Pulowski. Count two, Ashlyn Rand and Chuck Considas testified about the overt act there. Count three, Nick Edwards, count 4, Nicole Heidemann, count 5, Nick Balance, count 6, Zulema and Nick Edwards established some testimony to allow those overt acts to be considered. Count 7 had some testimony from Angela Yancey. Count 8, Coulter Cannon. Count 9, Nick Edwards. Count 10, Rick Wright. Rick Wright also on count 11 and 12. And also Nick Balance testified about overt acts in 11 and 12 also. And considering the standard I announced at the beginning of the ruling, court does find that there's sufficient evidence the state's presented to deny the motion on that count 6. Count 7 is the insurance fraud count. The defendant was identified as to that particular count, among other witnesses, by Craig Huff, and Angela Yancey established the date range that's in the count. Also Taylor Ballard, and the state did provide sufficient evidence regarding the allegations of the insurance fraud count to withstand the Rule 29 judgment of acquittal. Similarly, on count 9 of insurance fraud, again, the defendant was identified by Taylor Ballard. The date range was established by Angela Yancey, who testified also that occurred in Madison County. Prior count also, the venue of Madison County was established. And then also Angela Yancey established evidence relating to the allegation of a fraudulent claim as set forth in count 9. So upon considering the evidence presented in the state's case in chief on those counts, the court is denying the motion for the judgment of acquittal. And at this time, the court is going to permit some additional argument from the state as it relates to count 4, the first degree murder count, as it relates to JJ Vallow and the issue the court brought up. So Ms. Beatty, are you prepared to argue that?
I am, Your Honor. Thank you.
Right, I'll hear additional argument on count 4 then from the state, and I'll allow additional rebuttal argument as well from the defense.
Thank you, Your Honor. Your Honor, in looking at the case law and the relevant rules and statutes, the state really has 3 options for the court at this point. The first, and I'll talk about each of them in a little more depth, but the first option would be, because count 4 of the amended indictment did not fall within the scope of the court's December 8th, 2023 order to amend, and we'll get to that in a moment, the court can simply correct it under Idaho Criminal Rule 36 so that it conforms with what count 4 should be, which would be count 4 as set forth in the original indictment. And I'll discuss that more in a moment. Second, the court could accept that we do have a variance here and either instruct the jury on a variance between the jury instructions and evidence that they've heard, or the court under State versus Jones, which we'll also discuss in a moment, the court could address that variance by simply putting in September of 2019 in the count 4 jury instruction, which is very similar to what the court in Jones did, as we'll discuss in a moment. Third, and finally, the court would be within its discretion to reopen the case to allow the state to correct the indictment if the court does find that it needs to be formally amended. So as to the first option, the state did not move to, and the court never granted a motion for the state to amend the indictment as to the date or as to count the date within count 4 or as to anything about count 4. Under Idaho Code 19-1420, the state can only amend without leave of the court prior to entry of plea. Under Idaho Criminal Rule 7E, the court grants the state leave before amending a charging document. In this case, the state made a motion to amend the indictment on November 23rd, 2023 in 3 very specific ways. The first was to modify the subsection referred to in counts 1 and counts 3 from Idaho Code section 182403 sub 4 sub A to section 182403 sub 2 sub A. The second change requested by the court was to modify the language in counts 2, 3, and 5 from, quote, the defendants, Chad Guy Daybell, Lori Noreen Vallow, and Alex Cox, unquote, to quote, the defendants, Chad Guy Daybell, Lori Noreen Vallow, and or Alex Cox, unquote. Finally, the state requested that leave to amend the indictment to modify the language in Overt Act 10 under count 5 from quote, month, unquote, to quote, months, unquote. Importantly, Your Honor, nowhere in the state's motion did the state ever seek leave to amend any portion of count 4. On December 8th of 2023, the court granted the state's motion. The court's order states, quote, for the reasons stated on the record, the court will grant the state's motion. The amended indictment is ordered to be filed in the case, unquote. Subsequently, of course, the state did file an amended indictment, but in that indictment, it does appear that the date within count 4, the first-degree murder charge of J.J. Vallow, was inadvertently changed to the same date as the murder of Tylee Ryan. The state would note that the initial indictment was filed in this case on May 25th of 2021, and in that indictment, J.J. Vallow's death dates were properly set forth as the 22nd and 23rd of September of 2019. Just 2 days after that, counsel for the defendant filed his notice of appearance in the case. This matters in the court's analysis because it goes to prejudice and it goes to notice where we had an indictment with the correct dates for 2.5 years, during which the entirety of that time, counsel and the defendant were aware of that date range. And we'll discuss that in a moment as well. Ultimately, because this is a clerical error that needs correcting and count 4 was never properly, was just simply not amended in any legal sense because the state is not able to do that without leave of the court, and the court did not grant the state leave to do that. The court could utilize Rule 36 to make that amendment. Certainly, this would require a jury instruction of some type, and the state does not have a proposed jury instruction because the jury was read the indictment earlier in this case, of course, but that would be an option that would be available to the court. The second option would be for the court to accept that this is a variance, which does happen and is accounted for in the case law. And frankly, Your Honor, it's not a proper subject for a motion for acquittal. In fact, a date is not an element of a crime. And I know that that sounds counterintuitive, where our ICG standard jury instructions have the defendant's name, they have the date, they have venue, but venue and date are not elements of, they're simply not a factual element of a crime. And in Idaho Supreme Court's case, State versus Jones, dealt with that very issue. In State versus Jones, a defendant appealed from a lewd and lascivious conduct conviction, and he argued on appeal that the information, the charging document in that case, did not sufficiently apprise him of the nature of the charges against him. Specifically, the Jones defendant argued that the charging document did not identify the time, location, or information that he needed to prepare a defense. In that case, in that charging document, there was a range of numerous years where these crimes could have been committed. The Jones court explained that generally, a defendant cannot be prejudiced, quote, by the absence of specific details in the information when those details are already known to the defendant or are provided to him by means other than the information, unquote. And that pinpoint citation is 140 Idaho at 47. The court specifically in Jones rejected an argument about a lack of specific time set forth in the indictment. And I'll just read straight out of the case. Jones's next argument that the information was insufficient for failure to allege a specific time of the offenses is also without merit. Under Idaho Code 19-14-14, the precise time at which the offense was committed need not be stated in the indictment, but it may be alleged to have been committed at any time before the finding thereof, except where the time is a material ingredient in the offense. Time is not a material element of the crime of lewd and lascivious conduct with a minor. The Idaho Supreme Court, and I'm still reading from the case here, has stated that, quote, any other rule would too often preclude prosecutions in this type of cases where victims are minors and where crimes are not discoverable until sometime after their commission, unquote. So I think what we have here is the court explaining that these timeframes, there is there are other factors that can be taken into account here. And so while it's not directly on point because we're talking about a range of many years, and here we're talking about a variance in days, I think it's important to note that the court clearly didn't see a very specific tight time frame as an element of the offense in Jones. So the Jones court went on to explain that what we're really talking about here is variance. And diverting from Jones for just a moment, Jones also discussed the Windsor case, which the pinpoint citation for that is 110 Idaho 410. And in the Windsor case, the court really set forth an explanation of what variance is and the standard for variance. Quote, "The true inquiry is not whether there has been a variance in proof, but whether there has been such a variance as to, quote, affect the substantial rights, unquote, of the accused. The general rule that allegations and proof must correspond is based upon the obvious requirements that the accused shall be definitely informed as to the charges against him, so that he may be enabled to present his defense and not be taken by surprise by the evidence offered at the trial, and that he may be protected against another prosecution for the same offense," unquote. And again, the Jones court, after citing from Windsor, also discussed how variance between the information and evidence presented at trial, or between the information and the jury instructions, only require reversal of a conviction where the defendant was, quote, deprived of fair notice of the charge against which he must defend, or was left open to the risk of double jeopardy, unquote.
I do have a question about variance,
Yes.
because I've looked at some of the cases that do discuss variance, including the one I previously cited, State versus Anderson, 172 Idaho 133. And in this instance, I think looking at the context of how variance occurs, I guess the point I struggle with here is it appears to me variance typically comes up when, for whatever reason, jury instructions don't match the charging documents. And there is a presumption that the jury instructions should match the charging documents. And that's in a case, State versus Bernal, 164 Idaho 190. Here, essentially, what the state would be requesting is that we don't have a variance yet because the jury hasn't been instructed on something that varies from the charging document, but you're suggesting I permit or sanction a variance and allow the variance to come in to essentially cure an issue raised on a Rule 29, and see that as very different than any of the other cases. So are you aware of any authority where the court proactively let a variance occur to fix something in order to withstand a motion on acquittal?
And Your Honor, well, a couple things. So first of all, I don't believe that the defendant did raise this specific issue on his Rule 29 motion. I understand the court is considering it at this time. But I do think that I just want to make that clarifying point because I think it goes to prejudice.
And I believe that's totally accurate. It was raised by the court.
Thank you, Your Honor. But I believe in the Jones case itself, the court, Jones, I'll just read from the case. Lastly, Jones argues that the court's instructions to the jury constituted a fatal variance because the court added, quote, on or about, unquote, to the time frame of the offenses alleged in the information. He contends that this broadened the basis upon which Jones may be convicted. We disagree. The slight expansion of the time frame does not allow the jury to find Jones guilty of a different offense than that alleged in the information. Jones has identified no fatal variances between the information and the evidence or jury instructions.
Okay, I appreciate your response to that.
Of course.
question.
Thank you, Your Honor. So that would be the states, and I understand that, I certainly understand the complexities that this course of action presents to the state, but there is that third option as well, which is obviously a clerical mistake was made here. It's inconsistent with the initial indictment. It was not it was not a proper legal amendment. We're really talking about a clerical issue here, and I think that when courts look at reopening cases, that's something the court can do for situations such as this. So if the court declines to proceed with correcting the indictment on the basis that it was never properly amended, or if the court is unwilling to proceed with a variance, the court can reopen the case to address this issue, at which point the state would then amend it before resting, which would bring the state into compliance with Rule 7E. That would put the amendment in compliance with the rules and relevant statutes. So in addressing the court's ability to take that course of action, State versus Cutler is a good case for that. In that case, the Idaho Supreme Court stated, a justice presiding in a criminal case not only has the responsibility of protecting the rights of one accused of crime, but also an equal responsibility to the people of the state to the end that justice is not thwarted by mistake or inadvertence. The presiding justice under the circumstances of this case are well within his rights and his discretionary powers of trial procedure in permitting the state to reopen and present further evidence after the respondent's motion for a directed verdict of not guilty had been made, unquote. And I think that's very applicable to this case, Your Honor. I also think that another case that the court could look to would be State versus Huggins, 103 Idaho 422. In that case, the court noted that some reasonable excuse, such as oversight, inability to produce, or ignorance of the existence of evidence, must be established by the moving party. And Your Honor, we're all kind of falling on our sword here. This was clearly an oversight. We're talking about a clerical error in a subsequent document that was not in the initial document. This is exactly the type of mistake or inadvertence that the court could reopen this case for. And I think defense counsel argued earlier that it would be unfair to do that after the defense made a Rule 29 motion. I'm not aware of any legal authority that supports the assertion that making an oral Rule 29 motion on totally unrelated grounds tolls the state from doing that. But certainly there might be something out there that we're not aware of. But I do think that under this case law, if the court felt that a formal amendment was necessary, the court could reopen the case. Thank you, Your Honor.
All right, thank you for the citations and the well-argued points there, Ms. Beatty. Mr. Pryor, any response from the defense on this?
Judge, I'm going to work in reverse. And as far as reopening the case, the authority to reopen a case is almost exclusively applies to evidence, Judge. It does not apply to amending an indictment, information, or complaint. If the court recalls, I don't believe I objected to the original amendment to the indictment when we did that back November or December. The court read the indictment, went over it in detail with the state, and the state acknowledged that this is the indictment that they intended to go forward on. And from that time forward, that's the information that I relied on. And any change at this point, after the state has rested, is going to create a substantial due process argument for Mr. Daybell. In addition, it's going to affect the substantial rights of Mr. Daybell as well. The difficulty is this, Judge, is we have a very specific statute, 1914-20. 1914-20 says in pertinent part that the state may move after the defendant has pled guilty to a charge. Now he pled not guilty, and he did enter a plea of not guilty, and the state properly came forward and asked the court permission to amend the indictment. They then amended the indictment. And since approximately December of 2023, that indictment has remained in place in full force and effect. Now, they have that right to amend the indictment under 1914-20. But then we get to a very specific, a very direct rule, and that's Rule 7E. And Rule 7E says in pertinent part, Judge, that the court may permit amendment of a complaint, information, indictment at any time before the prosecution rests. To my recollection in reading the statute on short notice, Judge, I never saw the words variance. I never saw, correct an error. I never saw anything to suggest that they have any right to do any of this. And there's a State versus O'Neill, Judge, I think it's 118 Idaho 244 that talks about Idaho Code and the statute 1914-20. But Judge, the specificity of 7E doesn't say the court has the authority to go back and allow them to reopen. It doesn't say they have the authority to go back and create a variance. It doesn't say they have a right to go back and make a correction. What it does say is they may and they have to make any amendments or corrections prior to resting their case. There's nothing else that says, well, we got a little bit of wiggle room here and let's let them change things after they rest their case. And 4 lawyers had a chance to look at this indictment. 4 lawyers have had over a year to analyze this. And then after they rest their case and decide that the court picks up on the fact, and Judge, I mentioned to the court that there were elements. I wasn't going to key the prosecutor off that they had a problem. And if the court didn't catch it and there was subsequently a problem, someone else would have caught it and would have corrected it in the future. But they don't get to correct it now. They don't have any authority to say that. The cases they cite talk about other issues that have nothing to do with having the ability to change an indictment as I am preparing to present my case to the jury in this case on a capital murder case. They've lost their chance. They don't get to go back. Judge, I'm asking the court to dismiss the charge.
All right, looking back over a rule here, I have an additional question perhaps from Ms. Beatty. I'm looking at criminal rule 36 about clerical mistakes. Is it the state's contention that an indictment would be included among the documents that may be corrected for a clerical mistake? Because it does specify, it doesn't say anything can be.
It doesn't, Your Honor. And I think we take that position just based on the language in the rule that says, quote, or other part of the record, unquote. However, I will be candid with the court. I did not specifically check Westlaw to see. That was not one of my, I didn't do a deep dive into that. But I think that where we're talking about the criminal rules, judgments and orders can be amended, and any other part of the record. That's a very broad, expansive language. The record clearly would contain the criminal record in a case. I do think that that rule in its plain language could be applied to encompass an indictment.
And Judge, could I respond, please?
Yes, you may.
Judge, Rule 7 specifically says they're not allowed to change it after it rests. It's specific. And regardless of what Rule 36 says about other issues, and it's vague, we have a very specific rule being Rule 7. And Rule 7 makes it very clear. They don't get to amend. Regardless, they don't get to amend. It's a very specific rule that references this very issue. 36 is vague. This rule is specific.
Your Honor, may I briefly respond to that?
And that'll be the end of argument, but you may.
Thank you, Your Honor. The state would just reiterate that there is a process for making these substantive amendments, and there was not a substantive amendment made in this case because it did not fall within the scope of the order. And so we're not asking the court to make a substantive amendment when Mr. Pryor is citing Rule 7E or 7F. We're asking the court to correct what is clearly a clerical mistake not within the scope of the court's order, which is how I would respond to his citation of Rule 7.
Okay. So essentially arguing you moved to amend the initial indictment and the court granted the motion for specific grounds. And on February 20th of 2024, the amended indictment was filed, which has changes. And those were all drafted by the state. And your argument is that amongst the changes you put in the new amended indictment were clerical errors that should be corrected because they were not intended to be or should not have actually been amended. Is that essentially the argument?
That's correct. And I would take it one step further and say that as a matter of law, count 4 was not amended because we did not have leave from the court.
And Judge, I'd like to respond.
Okay, I will allow another response because I'm just considering all this. Mr. Pryor, go ahead.
Judge, they made the amendment to the date. They made the change to the date. They had an opportunity to review this. And then this indictment gets read to the jury and once again published for all to hear, including the 4 lawyers that are sitting across from me. And at no time do they catch that potentially there's an issue. And at this point, Judge, the rule is very clear. They have an indictment. They made the allegations. They're stuck with their indictment.
All right, counsel, let me take a brief recess, discuss this with my staff attorney, do some quick research and get prepared to make a ruling as it relates to count 4. I think time is of the essence to determine this issue, so we'll go as quickly as we can to get back on the record. I'll have the marshals advise you when we're ready to make an oral ruling.
They call me a god. 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 Let's go. I'm about to go off like a weapon. Fuel to the top, got a filled up engine. In my thoughts, obsession. I will not stop, no, I'm never second guessing. I got a God complex. Haters love to hate, but I never feel pressed. Got a lot on my plate, but I never get stressed.
All right, so I've been catching up today on this trial, right? Let me tell you something. Chad, he pulled all this together. He pulled all the strings. He made these people believe. I got to be careful with my words. How could anybody believe anything like this? Light, dark, zombies. Come on. Really? And I was watching the detective reading their messages back and forth. Very, very disturbed people. Very disturbed.
I am having anxiety attack right now.
Can you imagine what the Wilcox are going through right now? I'd be sickened to my tummy. Oh, I am sick to my stomach.
I'm serious. I just want to puke really bad. This is disgusting. Nobody caught this.
I had to go back and watch it again. I'm like, oh my God, did I hear that right? And I'm like, okay, I got to go live with this.
I'm glad you did because I don't see anybody else doing it.
Amanda says a bunch of people did. Okay, did you see the text messages today? Yeah, that's what I'm talking about. I did.
What text messages?
Between Lori and Chad.
No, I did not because I was running all over with parents.
How on earth wasn't it picked up? Who knows? They've had 4 years to get it right. They've already did one trial with Lori, okay? They should have, never mind, I'll be nice.
They should have copied what they did there and just applied to Chad. Come on now.
Right?
Like, how did they miss this crap? There's so many people that are supposed to be going over this, with a fine-tooth comb. Oh
You
my God.
inbox me or who? Are you talking about me or Grandma? Because I'm not good at checking Facebook, you guys. I'm going to be honest with you. That's why I'm going to get a burner phone, people.
My freaking hands are shaking right now.
Oh, you did? Okay. I got to give everybody my burner phone number. Then you'll be able to get a hold of me.
Oh my God. Oh my God.
I just think that's the most easiest thing for me to do. Don't you, Grandma?
Sure. If that's what you want to do, then you got
Oh,
two phones you
yeah.
got to.
Yeah, I'm not worried about it.
Oh God. Oh my God.
I'll just make sure I put a zip code from another state and I'm good to go. Good
Right,
to go.
Shawnee.
Huh?
What Shawnee says here. I'm screaming at the state, you bunch of. I'm praying this judge says he'll allow the state to change it. They should allow them to amend the document so that everything is all in line. They should. There's enough Idaho case law that allows that because it's clearly a clerical issue.
Okay.
Oh God.
I'm sorry. Go ahead, Grandma. You're smart. You go ahead.
You're smart too, honey. I'm just saying that's a clerical error. Obviously, we're talking about the same case as Lori Daybell. So, obviously we're talking about the same date range, everything. Obviously, it's a clerical error. And just because Pryor sees it and sits there smug the whole freaking time and says nothing.
He knew it too.
Amanda, me too. They've knocked a whole bunch of mine off of there because I called him an SOB.
John Pryor's stuck on stupid. No, I'm just kidding.
I just hate his guts.
Because the state rested their case.
The state shouldn't have rested their case until they went through everything with fine-tooth comb.
And that's his argument right there.
Well,
they can't go back and say, oops.
Yes, you can. Yes, you can. And there's case law. That's what the judge was saying. And that's what the prosecution was laying out. Oh, under this law and this Idaho law, blah, blah, blah. Yes, you can.
Interesting.
Clearly a clerical error because they know what dates everything is.
I mean, come on. The kids were on his property. Come on. I'm sure he's the one that dug, you're new to my channel. Okay. I'm new to this channel. My friend Rachel gave me the link to watch. I like the commentary. Oh, that's nice. Tell your friend thank you. And thank you.
Hey, Rachel.
How you doing? This is me. How you doing?
How you doing? He's cute.
How you doing?
Shawnee's cute.
Grandma, I'm so happy you're here. We have missed you today. But you know what? You took time for you and did self-care.
I did some self-care and then I did mom care, as you know, as I always do. Took care of my mom. I had to run her all over creation again after we got our monthly primping done. I cut an inch off my hair just so it was really, really in good condition. I'm trying to keep it in good condition because I want it down to my butt again. I'm growing it.
You know what? I'm gonna tell you something. I do some crazy shit to my hair.
Did you change the color?
I'm not telling you people what I did. I gotta wait. I gotta wait.
Why?
I gotta wait until the masterpiece is done. Okay.
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 Is it what you mentioned before though?
Yeah. And
oh God, I'm so happy.
I cut off 4 inches though. Oh.
Did you really?
I had to.
Thank you, Amanda.
It's okay. It'll grow back. It's all right.
I had to ask my hair lady. I said, "Isn't that last summer? Didn't I cut my hair all off last summer?" And she goes, "Yes." And I said, "Oh my, then it has grown lunch." She goes, "Yep, your last layer is coming off right now." And I'm like, "Okay, good."
Nice.
Got all my layers grown out now, and it's only been a year. It's getting long. It's way past my shoulders.
Nice.
So
I'm jelly.
Oh, I went on Discord
you got
and
purple in your hair? You got purple?
You have purple in your hair?
Cool.
God. Oh.
Aren't you fun?
Oh my God. Kit.
What?
Did you see the lady I sent you the picture of at lunchtime?
Yes, I laughed.
She had the blonde hair and the green glasses.
I noticed the glasses.
And like
I zoomed in. I had to zoom in on her face.
I was so funny. It was so funny. I could have taken a different angle on her and she looked more like Lori in in person. When she turned her head, it was funny, but oh my God. I'm like, Mom, don't move. Sit right where you are. I've got to do this. And I took a picture of the lady and I sent it to you. I thought, oh my God, I'm sitting here at lunch and here's this lady that looks like Lori Daybell. Ah! Little green glasses and everything. Chrome purple all over. Oh, the whole hair.
Chrome purple. Nice.
So it's like that gray, that pretty silvery purple, right, Amanda?
Nice.
That's so pretty. You know whose hair I like, but I'd never do it?
Who?
Kelly Osbourne.
What does she do?
Ozzy's daughter.
I know. What does she do?
Her hair's purple. It's so pretty. Oh my God. But I'd never do that to my hair.
Vivid colors are in, people.
I have no color in my hair. I have no perm. I have nothing in my hair. Oh, it's intense purple. You crazy rebel, you. I am so impressed.
I'm just filing my nail, guys. Just so you know.
My stomach is so upset right now. I'm so hyper. It's terrible. This is making me so sick.
I will tell you though, Judge Boyce, he is a very good judge.
He is a very good judge.
And Lindsay Blake, she's done a good job.
She has. She's really good, actually.
Yeah. She's going to be really hard on herself. You know that, right?
Yes, I do know that. But, live and learn. Don't screw up.
Right.
Yeah, Amanda, send me a picture, man.
Hey, hi. How you doing out there yet?
So, the lovely streets of YouTube, right?
What about it?
Well, you know how people behave sometimes?
Mm-hmm.
I have a friend who reads tarot, and every once in a while she will ask people in her chat if they'd like a free reading.
Right.
So she was going to do a free reading for somebody.
Whoa.
She will ask people in her chat if they'd like. What do you got going on there?
I turned my phone on.
Oh, and the volume was up.
Yep.
Okay. Well, so anyway, this gal was going to get a free reading, and the gal did the reading, but her internet stinks, so it takes like forever to upload something that's like an hour long. It takes like many hours to upload. And this lady started sending her emails, calling her all kinds of bad names and terrible things. And my friend is like this super sensitive, really sweet lady. She is really a tender-hearted person. She would never do anything mean. And this lady's yelling at her and everything. And she's really freaked out. And the lady started threatening her family and her daughter and saying these horrible things. Like, I hope this happens to your daughter, and I hope, your whole family and all this bad stuff this happens to them.
Who does that?
I know. And I said, oh, you need to expose her. And I said, first you block her off your phone, and you block her off your channel, and then you expose her. And the people on YouTube will take care of the rest. You don't do anything.
Okay, let's look at Amanda's hair. Hold on.
Pick is now my profile.
Oh, okay.
Oh my gosh.
Yeah. Nice.
Oh, that's more like a, that burgundy color.
Yeah, burgundy, like plum-like.
Yes.
But more bright.
It's pretty. I like it, Amanda.
Fun hair. Fun
Oh,
hair.
I convinced my mom today to get like purpley fuchsia kind of colored toenails, her toenails, and then put sparkles on top of it. And she did it. My mom's 82, mind you. So this was like clearly out of her comfort zone. And she did it. And it looks so great. And the first person that saw her toes went, which is the hair lady, said, oh my God, your toes are awesome. And she's so thrilled now.
That's cute.
And Mom's like, look, I'm so cute.
That is cute.
Right, she is cute. She's having a good time.
What's going on here?
Oh, excuse me. Oh, it is so freaking hot here. You guys, it's 91. I'm just dying. So hot.
Yeah, it's only 68 here today.
I would trade you today. This is hot. Better than that blue rinse. Do you remember that when ladies used to do that? They'd have a nice, white poodle hair, and then they put that rinse in there to get all the yellow out of it, and it would look blue.
For real?
Yeah, oh yeah. Don't you remember little blue-haired little old ladies trying to get the yellow out of their white hair? They ended up with blue head.
They should have used purple shampoo. Blue is to get the orange out.
Yeah,
No.
exactly. Because
That
they use
how-
purple.
Yeah.
Yeah.
Right.
Because it's the opposite on the color wheel.
Right.
It's about 18 degrees Celsius here. What is
What
that
is
like?
Celsius? I don't know what that means.
Isn't it like 60-ish? About the equivalent. 18 degrees Celsius is probably like 50, 54. Somewhere in there.
What's a Celsius compared to a Fahrenheit?
Well, we have Fahrenheit and Celsius is dude, it's like the metric system, It's like
I don't pay attention. I should, because
let me look that up, by the way.
People from the UK that come over here in Australia, my Aussie friends, I'll say.
18 Celsius to Fahrenheit is 64.4 degrees Fahrenheit.
18 degrees is?
18 degrees Celsius is 64 degrees Fahrenheit.
I could never see. That don't make sense, people.
The formula is insane. How to the conversion formula, it's weird.
So I'll just have to remember the number 18 Celsius means 60 Fahrenheit.
64, yeah.
And then I'll figure it out from there.
Oh my God, you guys, it's good to hear from you and talk to you. I didn't want to be away all day today.
Well, you know what? You needed that time.
I didn't need all the extra time after our appointment. This is my point. It's like I had to take Mom to Walmart afterwards, and it was just, you know how much I love that. You get her in there, and she's like there for 18 years. Then she wanted to go for lunch, and I'm like, oh my God, Mom.
She's there for 18 years.
It feels like forever in there, and they have, 4 or 5 checkouts open, and they're backed up all the way into the main aisle, and you're like, oh shit.
Why? Why is that?
Because they have 13 checkouts, but you only get 4 or 5 that have people running them. They don't hire enough people. Yeah, and then they got the self-check, which they have to take out of our stores because people go in there with a freaking vacuum, and instead of the vacuum, they like scan a pack of Kool-Aid or something, and they get out of there with a vacuum for 36 cents or something,
You're kidding me.
Oh no, they're taking all those self ones out, and they've got people manning them now to make sure people aren't trying to pull a funny one. Yeah, it's ridiculous. It's like, just stop being cheap and pay people. Did they say how long the judge was going to be, or just shortly?
Shortly. You said shortly. So shortly means a half hour.
Oh God.
Vacuum.
My Discord is blowing up now. They're like, oh my God.
You got a Discord?
Yeah, like a lot of people do.
I don't. I don't want one.
It's really kind of cool, actually. It's instead of texting each other, it's all in there.
No, it's a bunch of drama.
Okay, Hoover is Amanda. We need to have this discussion because I know you say you hoovered your house, and I realize in the UK, yes, I'm on Discord. It's not hoovering your house. You're vacuuming with a Hoover brand vacuum.
I got a dirt devil.
You have a Dirt Devil? I have a Bissell now. This time I have a Bissell. And it's super good with the dog hair. God, I love this thing. And I also have a Roomba. My mommy gave me her Roomba because she didn't know how to program it. And I was like, I don't care. I just want to go push the button when I want it to go.
Oh, a robot kind?
Yeah, you hoover your house in the UK, regardless of the make. Well, isn't that silly? Silly English people. Okay, Welsh people. Oh, here's my little friend that has the weirdo after her, the YouTube weirdo.
Who's that?
Her channel is Juniper's Tarot and astrology. She does forensic astrology, which is very interesting to me. And she's actually really good. She doesn't do tarot as much as she does the astrology stuff. It's kind of fascinating.
I think I've heard of her.
She's so nice. I've
Is she
been
the one that does all the lines?
Yes.
Yes. Okay, that confuses me.
Well, yeah, doing the charts is very confusing, but you get the idea. Like forensic astrology, they'll take a crime thing, a crime case, and at the exact moment that the person went missing or whatever, where the stars were in the sky, and they mean things. We don't say vacuum the house. That's just so wrong. Like we don't launder the laundry. We wash the clothes. Well, she's Welsh, Shawnee.
We don't say that in the house.
You walk on pavement, not the sideway. Sideway? You mean sidewalk?
What is she taking digs of us Americans for?
I know, right?
What is up with that?
Are you watered down American?
I ain't liking that tone.
You don't like that tone? You better watch how you talk to us Americans. And the car has a boot, not a hood. The boot is what you put on the tire to lock it up. That's not a boot. Oh, you're English too. I just love these people.
He's in Nottingham. Nothing.
The
Nottingham.
sheriff of Nottingham.
Good day, mate. How you doing?
Now I just want to go off on some Monty Python thing. Like the Black Knight skit. That's my favorite. Or the Knights of
Motorways. Now that's stupid.
What? Monty Python?
We drive on motorways. Nope, that one's stupid. Highways are better.
Highways are freeways.
See? Motorways.
Yeah, they are motorways.
Do you know
in a technical
motorways
term.
here?
But that's a general term. Highways and
Motor-
freeways are specific.
Motorways is where they race here. Okay? Okay.
That's true. That's true. Motorways are where we race.
That's right.
Kit, you are right as always.
Are you laughing without me?
I am laughing without you.
Majority of the time, yeah. I'll say that.
Grandpa's here.
And when I'm
Grandpa is
wrong,
here with Grandma. Oh
really,
my God.
really, really wrong. Really wrong.
In Wales, they drive on motorways, not highways. So we're having, a problem with their technical, and they don't vacuum. They hoover the house,
Yeah, they don't have sidewalks either.
regardless of the brand. Sideways, she said, not sidewalks.
What? Not racetrack?
No,
where they
racing
race
track is where they
car
race
bikes?
cars and
What
bikes.
is car bikes?
Race cars, bikes, etc.
You mean dirt bikes? ATVs? Come on.
No, like race cars.
I know. She says bikes. I got a grandson that dirt bike. He's a racer.
Oh no! Oh, yeah. Now you're picking on bikes.
Now I'm gonna get technical here.
Maybe she means motorbikes. Maybe they call them motorbikes there.
I sure hope not.
We call them
Dirt bikes,
motorcycles. Yeah,
Dirt bikes are
dirt bikes. Racing cars like Formula Ones, etc. Well, we know what those are.
Not store.
That's a racetrack,
I'm gonna
not
go
a
shopping
racing track.
at the store. See?
It's a shop, not a store. No,
Nope,
No.
I'm going shopping at the store.
no. Shawnee, you're cute, but that is wrong.
I'm going shopping at the store. Okay?
This is great. Come on,
No
Judge.
racing cars like Formula One. No motorbikes, not cycle. No, we got Harleys. There you go.
Oh, yeah, Harleys. You're going shopping at the shop,
That's right, I am.
and it's Asda, not Walmart.
Well,
No.
no,
No.
absolutely not.
No.
No.
Y'all wrong. You're more wrong the more south you go here. It's a Walmart.
I can't
That's why I
believe
think
it.
it's so funny how they talk down here. It's the Walmart.
I don't call pop
It's
soda.
pop?
Nope.
It's pop, not soda. What do you say?
I say pop.
It's pop.
I never
Well,
say soda.
I guess I buy pop, but I drink soda, I think. I'm having a soda. I'm having a pop. I'm having a
And it's
soda.
Home Bargains, not Target. I don't like Target.
Target
don't-
sucks.
Yeah, I don't go there.
Un-American place. No. Boycott Target. This is fun, I know. We're misbehaving. Misbehaving is the best. And it's a cooker,
It's a
not a
cooker?
stove. Oh, no, no.
Well, you know,
No. It's a stove is the top part and the oven is the lower part.
and then you got a smoker that's outside.
Yeah, or a barbecue. They're different.
Yeah.
A barbecue is not the same thing as a smoker. And it's
You
doorway.
can have a doorway and a porch. Those are two separate things, woman.
A doorway is the arch place, the archway you walk through to get to the porch. That's a doorway. Yeah. Yeah, sideways. Come on now.
Garden. You
It's
can
in the
have a garden in your yard. See? Your garden in your yard.
Yeah, the garden is the part where you deliberately grow either food or flowers, and that is within the yard,
Right.
within the perimeter of your property. Okay? So there's a distinction here. It's rubbish, not garbage.
Oh, they call TVs the telly or tubby or what do they call it? What do you guys call
Teletubby. Teletubbies.
Teletubby? I don't know. What do you guys
It's a
call
telly.
it?
They call it a telly.
What do you call
television.
television? Do you call it TV
Oh,
or
God. If you're growing food, it's an allotment. How
What
is an
is that?
allotment? That's not an allotment.
TV is TV.
Oh, thank God they don't call it the telly anymore.
Oh God.
That was probably in the 60s, though, honestly. On the telly. You guys are so funny. You're enriching our scope here of our language. It's interesting.
What is going on around here?
It's a sofa, not a couch.
It's been going on. Wait, look at this. It's been half hour.
They need to come back right now. I'm
Time's
under so
up.
much stress.
TikTok.
No, a sofa and a couch are two different things, if you ask me.
The sofa and the couches. Yep.
They are different, right?
Yes, they are. Trousers. I'd never call them trousers. Are you kidding me? Never.
Well, now.
Call them jeans.
Well,
Okay.
we're not talking about denim. We're talking about, trousers, pants, men's dress slacks.
No. Old people wear that shit, okay?
Okay, but flip-flops, not sliders. Flip-flops are flip-flops. They're different than
sliders are
sliders.
Sliders and flip-flops are two different things.
They're two separate things, yeah. Our words are much more specific than theirs. Pants go under your clothes. It's underwear. No.
What?
Trainers, not sneakers. Oh, my God. That is so wrong.
I call them tennis shoes. I don't like sneakers. I don't call them sneakers.
They're my tennis shoes.
Yeah.
They're my tennis shoes. Sweets, not candy.
Sweets is like pastries. And candy's candy.
Yeah, like a baked pastry that
Yeah.
are sweets.
Right?
Yes. You know,
Come
I've never had a cannoli in my entire life. I'm gonna do that one day.
Come on, Amanda and Sean. Come on. Come on. Bring us some more. Come on.
No, what is the other thing that they call your underpants? In
Undergarment.
no. No, there's another word.
Pasties, you make pies?
What?
I don't
Pastry.
I make
Pastry.
ice cream?
Boxer shorts. No, I'm talking about women knickers.
Knickers.
Your knickers. Those are your panties. Those are underwear in UK. Knickers. Not here. But over there they call them knickers. You know what knickers are.
No,
They're your under the clothes underwear.
Let's see how smug Chatty Boy's gonna be.
Now I got Juniper on my phone going, this is about Chad and that's about Chad. And the judge and everything about him. Chad is Libra. Meaning that he is in the scales of justice right now, like literally in court. His outcome is...
Pasture are two different things. Pastures is where cows go. Field is where the corn is.
Field, not a pasture. A pasture is where you put your cows out to.
Yep.
That is specific to having either sheep or cattle. That's a pasture because you are putting them out to pasture. A field is just a field. It could be dirt. It could be anything.
Corn. It could be a baseball field.
Cornfield.
Baseball.
It could be a potato field.
Yeah.
Pasture is where you...
What grandma
cows
said.
go into the pasture.
Cows go into the field.
Cows
No.
go into a pasture.
Oh, here we go.
Thank you.
Oh,
Please be
get-
seated. All right, we're back on the record on CR 2221-1623, State of Idaho versus Chad Guy Daybell. We took a recess after argument on continuing issues the court raised on the defendant's motion under Rule 29 for a judgment of acquittal, and in particular as it relates to count 4, after noting that the dates of count 4 in fact were dates that matched those in count 2 relating to the alleged murder of Tylee Ryan on JJ Vallow's count 4 dates. So the court allowed time for the state to research and further argue, as well as the defense. And the court's considered those arguments, and at this time we'll make a ruling as it relates to count 4 of the amended indictment. First thing I'll note is at the stage we're at this point is a ruling on criminal rule 29, which is for a judgment of acquittal. I already indicated the standard and the case law as it relates to the burden that the state has on that. I went through the other counts and denied the motion and reserved ruling on this count 4 for further research and consideration. The court, having considered the arguments of the state and the defense, I'm going to rule as follows as it relates to count 4. First of all, the court would note that the state has argued that in its motion to amend the indictment, and I'll note the indictment initially was filed in this case May 25th of 2021. An amended indictment which has governed this trial was filed on February 20th of 2024. So there was a time frame between May of 2021 and February of 2024, where the governing charging document was the initial indictment filed in this case. The state by motion in November of 2023 sought to amend the indictment. And the court went back and reviewed that motion to amend the indictment. And specifically, leave was sought as required by the rule to amend counts 1, 3, and 5. And the court did have an objection filed, ultimately issued an order on December 8th of 2023, granting permission to amend the indictment. Among the charges sought to be amended, count 4 was not one of those. So when the amended indictment was filed, it did have an alteration on count 4. And so the court thinks it's important here to consider this procedural history. The original indictment on count 4 sets forth the dates of the alleged murder of J.J. Vallow of on or between the 22nd and 23rd of September 2019. The state's argued then this is a clerical error that should be allowed to be cured, among other arguments. And looking at the history of the proceedings here, the court can make some conclusions. Number one, the court didn't permit or authorize any amendment to count 4 in the new amended indictment. So count 4 should not have been amended. Second, the dates that were put into the count 4 of the amended indictment of 8th and 9th of September 2019 mirror those dates of another count, count 2, which is the alleged murder of Tylee. Looking at that history, I think the court does believe it's a clerical error that led to the change of those dates. And so then the court has to consider whether or not there would be prejudice is one of the things I need to consider, the manner in which this could be fixed if it could, and whether or not there's any prejudice to the defense, which is always a big consideration and what the rules govern in seeking to protect due process rights of defendants. The court would note I also have to weigh that out with the right of the state to seek justice in a case with the charges it's filed. The state's argued it should be allowed to cure this, that it's a clerical error. The court notes that the defendant was on notice for a period of several years from May 25th up until that amended indictment in February of 2024. So nearly 3 years that the allegation was this murder of JJ had occurred on or between the 22nd and 23rd of September. In addition, the court would note that the evidence in the case all pointed to the dates of the 22nd and 23rd of September. And not only that, that same allegation's been made in a previous case that was tried last year by this court of co-defendant Lori Vallow with those dates. And of course, the defense here was aware of that trial, the evidence in that case, and a resulting conviction. So there's certainly no surprise that would come to the defense knowing that the dates that have been alleged are the 22nd and 23rd. So in terms of any prejudice, I wouldn't find that it would be prejudicial at this point to permit the amendment of the dates. The matter before the court now is just simply whether or not a Rule 29 motion could be granted, and then additionally, again, what could be done to correct this if it can be corrected. Going back to count 4 of the amended indictment, if I were to disregard the dates in there, the court does find there's been sufficient evidence in terms of the elements that are alleged, that the defendant, Chad Guy Daybell, was identified by multiple witnesses, including Ron Arnold and Whitney Arnold, that in terms of the elements of the murder that are alleged, there was testimony from Brandon Boudreau and Garth Warren, among others, about this alleged count of first-degree murder involving J.J. Vallow as a victim, and he was also identified by those witnesses, and then other testimony from numerous other witnesses that testified about the murder of J.J. Vallow in this case lead the court to believe there's sufficient information under Rule 29 that the motion for judgment of acquittal would be denied on that. And then leaving for the last part of the analysis here, the dates, the court having considered that history and the fact that count 4 just never should have been changed because there was no permission to do that, I do find it's an inadvertent mistake. I've also seen case law and cited by the state that the actual date or time of is not necessarily a required element of the murder charge. So while these jurors have already heard the information contained in the amended indictment, the court believes that the jurors can be fairly and properly instructed with a curative instruction or some other manner in which to correct what they've heard so they can properly be instructed in conformity with the evidence submitted. So the only determination the court makes here today is that the motion for judgment of acquittal as it relates to Rule 29 is going to be denied. And on one final point of that, I'll also mention that it was a matter the court raised itself. It was not specifically argued by the defense. And so the court again finds it's not prejudicial at this stage of the proceedings to allow for that change to occur. What I don't feel like I have had time to properly and fully ferret out on the issue is precisely how that will take place, whether it's through a allowance under Criminal Rule 36 has been suggested, an amendment to the charging document, or simply a curative jury instruction or explanatory jury instruction. I need some additional time to think about that. But for purposes of allowing the defense a fair opportunity to be prepared going forward with its case in chief, I am making the ruling that the Criminal Rule 29 motion on count 4 is denied. So the case will move forward. That count will be included in the court is going to issue a substantive follow-up order to the parties that will be directive in how the court thinks it's best to cure the mistaken dates in count 4. So that's the final ruling on the motion for judgment of acquittal. Ms. Beatty, do you have any questions about that ruling?
And Your Honor, do you need any further briefing from us or anything of that nature?
I don't believe I do at this time with the ruling made.
Thank you very much, Your Honor.
Any questions from the defense?
No, Judge, thank you.
Okay, thanks all for your consideration this afternoon. We'll be in recess until Monday morning for the defense case in chief to begin.
John Pryor's going to go have a drink.
All right.
All right, you guys, I'm going to get going. It's been a long day of me being here on the internet.
Thank you so much, Kit. I am so glad this turned out well for the prosecution. I appreciate you, and I am sorry I missed you today.
That's all right.
Thank you, Shawnee, for coming in today.
Yes.
Nice to meet y'all new people coming in.
I gotta go.
Okay, kiddo. I'll see
Okay.
you later.
Love you guys. Bye.
See you tomorrow.